Say that's noteworthy, you can write it down on that. So, now, one last thing I want to say is, if there are certain situations, now the questions I've heard are more general, and that's good. If there's certain situations that you're aware of, I would prefer you not ask me those kind of questions. I will answer hypotheticals in general. And here's the reason why. And not only in the Brown Act area, but anything that, as attorneys that we give advice on, there's a lot of facts that can, you can state certain facts to me, and I can give you an answer. And I've had this with clients. And then a little later, oh yeah, there was this, and it changes the answer 100%. So I can only give an answer to the facts you give me. And obviously, if you're not an attorney practicing in the area of the Brown Act, you wouldn't know what are the key facts to know. So anyway, we'll go from there. If you can put the next slide for me. All righty. Start and answer part of your question. The Brown Act, or I think someone else asked, the Brown Act actually isn't designed to have more participation of the public in it, and I'll get to that. It's what we call a transparency law. That's why it was put in. Plus, Ralph M. Brown wanted to live in immortality. He was an assemblyman or something, so he put his name on it. Interesting thing is, this is requiring transparency, that the council members or the planning commissioners or whoever it might be is not making decisions or deliberating on things, not just making a decision, but actually deliberating, discussing things outside of the public. The public gets to hear all that, and should. This is your elected officials, you should be able to hear how they come into conclusions. Guess what? The legislature thought this was great for local government, but they didn't do it for themselves. Draw your own conclusions. But. So anyway, this is, and that's why it's called an open meeting law. It's for that purpose. Now, a little bit later, we'll talk about the public participation and what that has, and I'll answer more questions about that. Okay. Now, who's subject to it? Generally, the law says a legislative body, and it includes a lot of different types. You immediately think of the city council, and I imagine most of you have been to city council meetings, and you see how that works. But the commissions were created by the city council, and they meet regularly, so thereby they are legislative bodies, and so they have to comply with the Brown Act. Now, sometimes they use the term ad hoc. Now, Brown Act doesn't use that term, but let's say a quorum of the city council would be 3 members if they're a 5-member council. So 3 members of the council can't meet to discuss things that is within their purview unless they post an agenda. Okay, and we'll say more about it later. So sometimes the council will set up ad hoc committee, which is 2 council members. Now you don't have a quorum meeting, and they'll study something and meet with staff, or meet with the public or whatever, and then they'll come back and report to the full council. They don't get to make any decisions. It's just they come back with a recommendation to the full council, and that's okay as long as it's a short-term, one project type of thing. If it's, even if it's an ad hoc committee, if it goes on for a long period of time, and let's say it's like some kind of budget committee, and it meets regularly, and it goes on for years, that's what we call a standing committee. And even though it's less than a quorum meeting of whatever the council members, it requires that their agendas be posted, and that the public has a right to come in and see what's going on with that committee. So the other thing that's very important as part of the definition of what's a legislative body, if the city council creates it, that's the first thing, the flag goes up. And if they created it for a short term, maybe it won't need a Brown Act posting. but they're created for a longer term type thing. Every time issues come up, they're not just dealing with one issue, they get to review all those new issues. Then it's something that would require the posting of the agenda. And sometimes people get confused in different cities. Recently, I entered into a position as a city attorney, at least on an interim basis, in a city, and I'm finding that, oh my God, how long has this commission been around? And have you been posting agendas? They don't like it when they point those things out. But I'm trying to help them, not go to jail. But that's another thing. I think there's a penalty slide. Actually, if you violate the Brown Act intentionally, it's a misdemeanor, which does potentially have jail time to it. Now, this last part is, well, let's say, yes, sir.
Then that's the point, if it's intentional. If it's not intentional.
Yeah, if it's accidentally, probably, usually a crime, especially one that's like a misdemeanor, you have to have committed it, and you also had to knowingly do it. Knowing it's wrong, you did, So that's the way that it's set up. Not just for Brown Act, for anyone.
But then a blatant violation would be if there's more than two. If there's, say there was three speaking, that's a blatant violation.
No.
It shouldn't be.
Meaning they had a meeting and there was no posted agenda? Yeah. Well, new commissioners and city council members are required within 6 months of taking office to take the AB 1234 training, which I've also done. That's a 2-hour training. And it teaches them all these things. So it's hard for them to say I didn't know or I didn't do it intentionally. And I think a lot of people come in already know the quorum rules. So if I'm approached and told, look, this has been happening, I'll go and tell them, because I want to make sure my client doesn't get into trouble. And most of the times when I see some Brown Act violation, not all the time, but most of the time it's accidental, because there gets to be so many rules. We'll go over some of them.
What was that AB you referenced?
AB 1234. It's 1, 2, 3, 4. That's an Assembly Bill 1234. It's in the government code, and it requires, it was actually requiring that council members so on keep track of their expenditures and verify them. But then there was this other section in it, which we all, us attorneys all remember, is that there needs to be that training. And then after the person's in there, 2 years later, you got to take it again, because there's usually updates. We have a PowerPoint presentation for AB 1234, and we're constantly updating. We'll pull out the last one we did and re-update it because there's changes. It also deals with conflicts of interest and stuff like that, and the FPPC, the Fair Political Practice Commission, is constantly updating theirs to make it simpler. And let me tell you, it just gets more difficult.
And this is only applicable in California?
Yes, it's a California law. Newly elected, that was something, or newly appointed members. Once you're appointed or elected, the Brown Act applies to you immediately. So, like, let's say you just got elected, maybe you haven't even been sworn in yet, and you start talking to 2 other council members, let's say it's council. That's wrong, because the Brown Act already applies to you. Generally, when I'm in that situation, I make sure that I meet immediately with the newly elected people, give them some idea. Sometimes I sit there and talk to them what the legal issues are in the city or what things are going on, but I work in the Brown Act and so that they don't get into trouble. That's a terrible way to start out your tenure. Yes?
So just to clarify, so if let's say if there's 4 council members in for a gathering or something like that, if they're there in one particular place, as long as they're not discussing anything related to the city or any type of that discussion, but just being there to say a birthday party or whatever for somebody that they have in common, is that acceptable?
Yes. Okay. And I'll get to that a little bit later, but yes, there's several areas. The main thing is the public has a right to know and see you deliberate about the things that are within your jurisdiction, the things that city councils decide, for instance, or what planning commissioners decide. The public has a right to hear you deliberate about it and hear you make the decision. Okay,
Question.
Maybe I should go to another slide. Yes, go ahead.
When is a body allowed to have closed door? meeting?
We're going to get to that. Yeah, he's asking about closed session, and I'll explain. We have a slide that even shows some of the types of closed session items, and I explain why that is allowed. Oh, there we go. Here's the kind of ways that you can get in a trap and accidentally get involved in a Brown Act violation. There's all kinds of ways that it can happen, especially now with the technology. Do you know that the Fair Political Practice Commission, which we usually just call FPPC, they haven't caught up with technology. They're busy redoing their rules, but they put some out for technology, no, they haven't. So as attorneys, as you know, we practice law. Means that we have to figure out what is the main purpose of this law and what should we tell our clients to help protect them. Now, I tend to be a bit conservative because it would be so embarrassing if one of my clients went to jail. We're not going to let that happen.
What's the frequency of someone going to jail
Depends on the county.
in California?
Yeah, because the county, the person that enforces the Brown Act is the district attorney. Like for instance, the LA County District Attorney's Office has a public integrity unit. I believe San Bernardino County does too, but they're very aggressive. Not necessarily putting people in jail, but making the councils do a whole meeting over. I had a situation where they made a mistake in how they posted the agenda, and somebody who didn't like the decision was made, called the district attorney, they came out and made them do the whole council meeting all over again. And so, anyway, I had one time, I went to see a commission. I was asked to go talk to them because they were emailing. Now, this was a number of years ago, but they were emailing each other. Just blatantly emailing each other and talking to each other with these emails. Now it would probably be a chat room or something, but at any rate, they said, why don't you come in and talk to this commission about the Brown Act? So I come in and I'm telling them about the Brown Act, and all of a sudden one of the commissioners, this is amusing to me, it might not be to you, but one of the commissioners said, excuse me, why were you asked to come and talk to us about this? She was one of the ones that was doing the emailing. So, well, because, you know, we periodically tell people about the Brown Act. So anyway, texting, same thing. Now, blogs and social media things get to be a little bit difficult because if two people are chatting back and forth on a blog and there are two council members, you know, that's not a problem, but, you know, the FPPC hasn't decided, well, what if there's a third one listening to that, you know? I generally recommend to my clients, don't do it, but there's a compulsion to do it. So I say, well, you know, one time a council member called me up and said, there's two my colleagues, they're talking on the social media about something that we're going to be making a decision on. And I said, she said, and the person who runs the blog is asking me to give my opinion. I said, it's right that you called me. Don't do it. Don't get involved. Yes?
So the question, made ourselves districts in Upland. This specific district councilman would be more of the appropriate like representative to bring that up to the council?
Yeah, that would be true, but I want to go back to what he's talking about is how could they set a special meeting without discussing it, okay? The answer is that the mayor can call a special meeting or a majority of the council can. And the Brown Act has an exception that if all you're doing is calling a special meeting, you may talk amongst each other about calling a special meeting. You do not get into the merits of the issue.
There has to be a reason for a special meeting.
Yeah. Well, you say it in general terms, but you don't discuss it. You say, there's a traffic problem on First Street, and I think we need to set a special meeting. It's urgent that we get to it. And that's as far as you say. You don't discuss anything else. You could set a special meeting.
Vague and ambiguous. not
Well,
specific.
yeah, you don't want to get into debating it, and then you are violating the Brown Act.
Maybe even not say a problem, an issue.
Excuse me?
Say it's an issue, not a problem. If you say it's a problem, then there's something.
Now, this man is splitting hairs.
Yeah.
Okay, let me see what, a serial meeting is where council member A talks to council member B, and they discuss an issue that's coming before the next council meeting. Then council member B goes and talks to council member C. That's a serial meeting, and it's a, hey, I was talking to A, he thinks this is a good idea, and you're in violation of the law. Well, obviously, the telephone, and any kind of informal discussions. I used to represent a city where after the council meetings, the city manager and the city clerk would go out to the Pancake House or one of the places, have some coffee and dessert, and sometimes the council members would come and they would debrief what happened at the council meeting. And they invite me to come along, so I'm sitting there, oh my goodness. But generally, there was only two, so I, So, anyway. Okay. All right, now, these are the rules here, but I want to explain what it is, and I think it's going to answer some of your questions. Again, this is a transparency law, okay? You have a right to know what the council is going to talk about. Because how would you know if you want to go to the council meeting or not if you don't know what they're going to talk about? Okay, and that gets to the public comment in a moment. So the agenda for a regular meeting has to be posted 72 hours in advance. So you can, and if you have a web page, which you do, it has to be on that also. Before it would be they would post them or put them in the paper and so on, but this now requires it on the webpage. Most people use that now. And so you can look at the agenda. It actually says in the Brown Act that you're supposed to give a general description, a description enough that if somebody that is interested in it would get the hint that that's going to be discussed. And they say maybe 20 words or whatever. Yesterday I looked at an agenda for a city and they had this whole long thing. It must have been 60 words. And I looked at it and I said, well, that's a little bit long. And then I read it and said, oh, what the heck, the public will know everything. So you overdid it, what the heck? You're not going to get in violation of the Brown Act, you tell them more information. So that's what happened. Now, the special meetings that you're talking about is a little bit different rule. The 72-hour rule is for the regular meetings. You can set a special meeting, and then there's several rules that go with that. First is you have to tell the newspaper, anybody who's asked to be notified of a special meeting, there's a list the city clerk will have. They have to give them all special notice. Of course, you do have to give the council members notice of the meeting. So in the case the mayor called it and the other ones don't know about it, they all have to be served 24 hours in advance. And so, and then you can have your meeting. Once you have your meeting, that meeting, you can't add anything to the agenda. There's no late adding anything to the agenda. And you can only discuss the items that are on the agenda. And generally, the public comment for those will not allow comments about anything other than what's on the agenda. Okay. And so anyway, that's the way that works out.
More for an emergency situation, or could it be?
There is another rule, I haven't actually ever seen the city use it, but there is an emergency type situation. Let's say I have a terrible windstorm and there's an emergency. But that even is covered by other things that can be handled administratively. Yes, ma'am?
So point 4 up there, the nothing one, does it apply to point 1 and point 2, or does it only apply to point 2, special meetings?
Okay, yeah, this is, okay, we'll just segue because there was a question about public comment, okay? And that's where this point is talking about. So when you come in, and there's been some frustration, I understand, but if you come up and say, let's say it's the street, it's not on the agenda, so you come up and say, we're having a problem on First Street, that people are going zooming down at 80 miles an hour, we need road bumps or whatever, you know, whatever it is. So you make that comment. You'd like to hear the council say, oh yeah, well they can't. Now, why is it that they can't comment on it? Because the rest of the world wasn't given notice that they were going to talk about First Street. None of the people on First Street were told that they were going to be talking about First Street. So that is a lack of transparency. And so that's why, and then I got that point, I think is the most important point, but also talk about subject matter jurisdiction. Which means if you come in and say our schools are crummy and we got to do something about it, that's not in the subject matter jurisdiction of the city council, that's in the subject matter jurisdiction of the school board, you see. So the comments and public comments are supposed to be only about things that the city council can do something about. And I've seen the city councils here and otherwise will allow a little bit of freedom in that area. Which brings me to my next point, and that is, again, the Brown Act is for transparency. Okay. A lot of people will say, you know what, you're stifling my freedom of speech. I have the right to the freedom of speech. And that's true, you know, I think it's in the First Amendment somewhere. And the idea is, though, that the council meeting is not a public forum. If you go out with protest signs and everything out in the park and everything, the park is a public forum, but the council meeting isn't. The council meeting is a business meeting to take care of the business of the city. They are required to have a public comment section so that the public can come in and make comments about things that they want to. And different cities handle it differently. It could be comments about the agenda items or comments about things like First Street that's not on the agenda. But not that he lives on First Street. I made that up. It was asked about before, closed session. Okay. There's a reason why there's only about 7 or so items that you can go into closed session about. And it's very limited and very strict. And I remember going to a program put on by the LA City Attorney's office, district attorney's office, by the particular unit that takes care of these things, the integrity unit. And they were telling how they look at this. Oh my goodness. One of their rules was, if you have to figure out a way to get something in closed session, don't do it. It's either clearly in closed session, but if you have to figure out a way to jerry-rig it so it goes in, don't do it. And it's a good rule. But let's take litigation, for instance. Now, you want to settle a case. Somebody got injured, a tree fell on them or something. And they want to, you want to negotiate, right? Now, the reason why you have closed session is if you did an open session and the council says, settle it between this number and this number, well, somebody in the public might be the one that is suing that, right? And so you put the city at a disadvantage by making them do that in the public context. So litigation has to be done in closed session if you're discussing things that would put the city at a disadvantage. And usually you go into litigation for settlement purpose to talk about that. Real estate negotiations is interesting. You can only go in to closed session to discuss the price and terms of payment. And they're very strict about that, of real estate negotiations. Now, why do I say that? Well, you think, well, what else would you go in? You know, you say, all right, we'll pay this much for the property, you don't want the other side to know. But there's another thing. The perfect example is the city of San Diego. They have that beautiful stadium down there. And this is a few years back. But they went into closed session to discuss the new stadium. Well, what did they do? They looked at renderings and started talking about what it should look like. You know, we should have more trees or whatever. You know, they discussed that and they got nailed on it. And so now we know that we can't do that. The only price and term. Public employment is, there is a confidentiality if somebody is employed by the city. Public employment, the council, for instance, they only hire a couple of people. They don't, for instance, they hire the city manager. So they can discuss that. The city manager is a direct report to the council. But then the city manager hires everybody else. So with a few exceptions, a lot of cities hire, the council hires the city clerk, or the council hires the fire chief or police chief or whatever. But generally all the rest of the employees are under the purview of the city manager. So there's only a few that they can discuss about hiring, appointing, and stuff like that. City attorney is another one that the city council does. And so you can go in on public employment like this. Now, let's say some person down the chain of command, a council member gets irritated about that person and wants to discuss that, you know. Or they fire somebody and it was a friend of the council member and they want to go into closed session and discuss that. They can't, because that person doesn't report to them. Only people that report to them can they do. So, you know, maybe some of that's important for you or not, but anyway, I just start gabbing, I keep going. Anyway, labor negotiations. Now, you can see the beauty of why you have to go into closed session for labor negotiations. Is again the same thing. You say, well, offer them this or offer them that. If they're sitting in the audience, they'll know how much authority you have. I had a case, the city will remain nameless, but there was a big case that involved police officers and sexual misconduct and the whole thing. And there was a leak from closed session. And when our people would go to negotiate, they would not settle because they knew what was being said in closed session about the case. So they wouldn't settle. And my partner at the time, in the previous law firm I was in, he was frustrated. They wouldn't accept it. So one night, the council sat in closed session and says, okay, this is our bottom line number. We're not going to go any further than that. And all five of them said, that's it. So my friend goes to talk to them. Oh my goodness, they settled. Because they knew that was the most money they're going to get. Another reason why you want to go in and discuss these things in closed session, except for somebody leaked that. And that's unfortunate. It's also a way to lose your position. The only people that, let's just talk about the city council now. The city council's boss is the public. So only the public can fire a councilman. Okay, and it's called a recall, right? However, if you violate, and there's probably a couple others, but I'm talking about the Brown Act today. If you violate the confidentiality of that meeting, then that closed session item, you can lose your position as a council member. The grand jury has the power to take it away from you. Okay. Now, if something is happening in closed session that's illegal, any council member has a right, and maybe even an obligation, to go to the district attorney and tell the district attorney that there was a violation of the Brown Act. And that's happened. And then what happens is the district attorney gets involved in it, and then pretty soon the council has to take minutes of their closed sessions, and then those minutes are turned over to the district attorney so they can monitor and make sure they're not cheating again. So anyway, I've gone off on a tangent.
Mr. Brown, real
Yes.
quick question. Who determines whether there are minutes in a closed session?
It would be the district attorney. Now,
I mean, for a city council, when they have closed sessions, who regulates whether there are minutes for that closed session or not?
okay, if the district attorney hasn't enforced it for some reason, the council can decide that there would be minutes of the closed session. But those minutes should be taken by somebody that's in the closed
Like the
session.
city clerk?
Yeah. Well, no, the city clerk is not in closed session. And so they would have to figure out a way to take those, and then those would have to be securely, public can't see those. No one else who wasn't in closed session can see those minutes.
Right.
Now, I've been in council meetings where I wish the heck they would have taken minutes. I remember one time negotiations were going on, labor negotiations. And the council couldn't finish it at the beginning of the meeting, so they came back afterwards. Okay, we're sitting in there, it goes past midnight and 1 o'clock, and they're making decisions, and they made the decisions. I heard them make the decision. They had a labor negotiator there from another law firm who heard them make those decisions. Okay, and this is after the point of no return, after midnight, right? So we come back to the next council meeting, and the labor negotiator gives them an update. Said, what the heck? Why did you offer them that? And he said, well, you told me at the last meeting. No, we didn't. You know, they don't remember because it was after midnight. So that's just something to think about, you know. And if they had minutes, you see, that wouldn't have been a problem. Yes.
Can you go back to when you talked about public employment, about the hiring?
Yeah.
You mentioned something about that? I didn't quite catch it.
Oh, the city council only hires certain people. City manager, city attorney are typical. Sometimes they hire a city clerk, and on a rare occasion, maybe the police chief or something like that. It has to be in the code to say that they could hire them. Those are people, positions and so on, that they can discuss in closed session. Everybody else down the chain, they can't because they're not hired by the city council. We call it like direct report, you know. So the other people are technically hired by the city manager. You know, they have human resource department and stuff like that, but technically they all work for the city manager. All those that are not appointed by the council.
Two questions on closed session. Workers' compensation cases, would that be considered litigation or public employment?
It would be litigation if they're trying to settle a workers' comp case. But generally, those things are contracted out. If there was a need for a council to discuss that, they would go in
Does
closed
the council
session.
have to approve a workers' comp settlement?
Yeah. Yeah, if they're negotiating stuff like
So it has
that.
to
But
be-
I rarely see that in there because, like I say, sometimes that's contracted out. In fact, a lot of litigation, if the city is a member of the California Joint Powers Insurance Authority, which is a group of cities and governmental entities have set up an insurance pool, the part of the contract is the council don't get to make the decisions, the pool does. So we turn it over to the pool, they hire the attorneys, they fight the whole thing. When it comes time for settlement, they settle. You know. So that would never come to
And then
city
in
council.
closed session, public employment, would that take into consideration non-paid, they're not employees, but non-paid officials or commissions, or will some get a small paycheck? Possibly that's why they make them employees?
Well, again, if they're not hired by the city council. Now, the city council does appoint the planning commission, I should say, for instance. Well, whether they want to remove a planning commission or not is not in closed session, it's an open
So
session.
that can't be in closed session.
Okay?
Oh, okay, and then it's same thing with some semi-volunteer positions that are, well,
Yeah, I wouldn't see that there would be any that the council would be involved with.
now if they had a problem with a appointed commissioner, let's say, could that be in closed session? And it's not, it cannot.
No. Yes, ma'am?
Consultants.
If the consultant is the city attorney, that's an official of the city, they can do that. Other consultants are hired by, not hired by the city council, except for if it requires if it's a smaller contract, the city manager will probably do it. Now, let's say it's a consultant that the city manager can't take care of. The council will approve them in open session. I can only think of one position that would be semi-consultant of the city attorney that can go into closed session. But consultants are generally not that kind. They're not public officials. In fact, when I draft the contracts, I put in there that they're not a public official. Yes.
In closed sessions, who's usually the ones that are allowed to be there, other than the council members?
Let's say a tree fell on somebody, you probably have the public works director in there, and you can bring them into closed session because they will have information that the council needs to have to make the decision.
But typically, is it the city council, is it the city attorney, is it the city manager? And if so, by day, does the Brown Act apply to them as well too?
That they can't disclose what was said? That's correct, yeah. Generally, the city attorney is always in, unless it's about the city attorney. but they're always in, and the city manager's there, and any other staff member that's necessary to go over it. Sometimes you have outside counsel in there because they're handling like a labor negotiator or somebody. So they can go into closed session, and they're bound by the same thing. You can't leak the information. Yes.
Again, if I could, closed session, when we talk about who's allowed in, who's not, I understand the concept of it. Is it, what I thought I heard you say was the city council can decide if they want to have minutes of the meetings. Is there anything inappropriate with saying during closed session, if the city clerk, who normally takes minutes of an open session meeting, will be present during the closed sessions, and subsequently, I realize not taking and doing a dialogue, but minutes, briefings of the closed session, is it appropriate for the city council to say, from this point on, we want to have minutes, and we would like to ensure that the city clerk is present. The city clerk would be appointed in keeping the minutes and securing them for a later date.
I think that's possible, and especially as city clerk's a confidential employee.
Correct.
Yes,
Thank you,
ma'am.
sir.
Yes, regarding real estate negotiations, does the property in question have to be public, or can that remain secret? Or, I'm not sorry, secret, closed session?
The listing, there's a set of, in the Brown Act, of, they call safe harbor listings, and it tells you how to list these things. If it's real property, you're required to say the address of the property, you're required to say who the city negotiator is, you're required to say who the negotiator for the person you're negotiating with, that owns the property or whatever. And you have to list all those things. And then the last thing you list is what is to be discussed, price and terms of payment.
Okay, that's all has to be public.
Yeah, it's on the agenda. It's on the agenda. It has to be. There are certain things that sometimes in litigation areas, anticipated litigation or something like that, like where the city's planning to sue someone, and they feel that it would be problematic to tip them off, you probably wouldn't put the name. You can say one potential case and discuss it, because they'll void service or something, and they don't know they're going to be sued.
So it's like it's just a general sale of public land.
Another thing that happens that I might add is sometimes there's a temptation. Let's say the city council goes into a closed session to discuss labor negotiations, and the labor negotiations is with one person, unrepresented, means they're not in a union, and it happens to be the city manager. Sometimes they would like to invite the city manager to come into closed session so they can talk turkey, right? Wrong. The only reason why you're allowed to go into closed session to discuss it is so the person you're negotiating with doesn't know what authority you have. So many times I found myself in the unfortunate position of being the labor negotiator with the city manager. So the city council gives me direction, I go talk to the city manager, blah, blah, blah. Yes.
So after a real estate negotiation is closed, then that information has to become public.
Oh yeah, once the sale goes through, it becomes public.
Or a labor negotiation or anything.
Yeah. What happens is they give direction, and they say, okay, if they'll settle for that piece of property for $3 million, do it. So what they'll do is just give direction. No final decision. They just gave direction. They go out and they say, okay, we'll sell it to you for $3 million or whatever. Then they bring it back at a subsequent council meeting on open session to approve the contract. Same with the employment contract for the city manager or anything else like that. And then after that, it's open. Now, there's one more thing. It doesn't happen very often. But the council, the majority, well, it have to be the whole council really to make it work. They could decide to disclose what was said in closed session if they all agree. Okay? And then it won't be a violation of the rule if they decide. That it should be. And that happens occasionally.
I'm thinking of an attorney-client privilege. If in closed session, there's some kind of employment situation, and the entity gives you as the attorney direction to hire an investigator, you're going to hire an investigator to do whatever, then what, is that all client, attorney-client privilege, since the attorney is hiring the investigator, not the city?
Well, the city pays for it.
Right, but it doesn't do the hiring. So-
Usually, the reason why the city attorney would hire the investigator, whatever, is to keep it, whatever the investigator comes up with, is still have the attorney-client privilege.
Okay.
That's why they do that.
That's true.
Okay, we already covered all that, so. Well, these are the kind of things that could happen if like I told you, in that one city, they posted the agenda wrong, and so they notified all the decisions, so they had to do them all over again. And this is the fines and imprisonment. A misdemeanor is 6 months in jail tops and $1,000 fine. And this is the one, most elected officials don't want a bunch of bad press, right? Especially if they want to run again, so. All right, next one. Oh! Well, we already covered this. Any more questions? Yes, sir.
So when somebody's brought into that whole session, do they need to sign a disclosure?
No, because the general will be staff people, the city attorney provides disclosure. The question is, if somebody comes in closed session, they have to sign a document saying, they're not supposed to talk about it. The city attorney will make sure they understand. Yes.
In closed sessions, because I think this would be real difficult to prove, if you suspect that someone in closed session is leaking information out, but you have no way initially to prove it. And I mean, how do you know about something like that when you're one of those internal members and you suspect that this person is somehow disclosing information outside of closed session? Well, what kind of a remedy or what kind of action should I take?
Well, did everybody hear the question? The question is if you think somebody in closed session is leaking the information out, the thing is that it depends on whether the district attorney wants to investigate it. It might be too difficult and take too time consuming because they do have a couple other things like murder and everything they have to
Sounds good.
take. Yeah, but it all depends. If it's really grievous or something like that, maybe then I look into it. But I haven't heard of that happen.
I'm thinking unintentional.
And plus, the grand jury could look into it because they have the power to deal with that particular thing, the leaking of information. Any other questions? Yes?
When was the last time someone was prosecuted for violating the Brown Act?
Next week.
It depends on the county. But when I first started giving lectures on the Brown Act, we would get to the end of it. Now, mind you, it's a couple decades ago. I know, I don't want that old. But anyway, I would say, okay, here's the penalty, right? But quite frankly, nobody ever enforces that. Well, that was up until about 5-10 years ago. And now I have to say they do. They do enforce them, and they do go after people. In fact, you probably read it in the paper when they've gone after people and stuff like that. So I wouldn't be surprised in any particular county that there's been a recent type of Brown Act issue. I can't give you any statistics. Yes.
Well, and I'm thinking something like that on social media. I can see it right now posted. This person violated the Brown Act on this date and this date and this date, and this is what they said. That's a clear violation. So you read it on social media, someone else reads it and says, oh yeah, they violated the Brown Act. But it hasn't been adjudicated that there was a violation.
Yeah.
Officially.
That's not fair.
Well, we get into the fake news.
Yeah, fake news.
It's
Yeah.
like,
What can I say?
Exactly. Okay, gotcha.
Got to have your day in court, right?
Yes.
The lawyers have to eat.
Totally true.
All right, thank you very much, everybody.
Okay, before you leave real quick, I want to give you a commercial for our next workshop. We have a flyer back there, and it is in April. We are having a workshop that's going to be presented, it's on economic development and the challenges we face. We want people to understand what it means to